The problem with this mechanism is that what is the worst thing that can happen for a state? That if the investor wins the case, he will have to pay a compensation. That compensation can be very big. And it's based not on the investment that the investor brought, not the capital that they brought to Malaysia to invest to build a factory. In some cases, it's the future profits that the foreign investor lost because the government adopted certain regulation that decreased the profit of this foreign investor. That is the case of tobacco. The regulation, hey, put a label that says tobacco kills, and then Philip Morris sued Uruguay saying, hey, you are expropriating us, but we're not expropriating nothing. Oh, you are expropriating our future profits, because with this we're going to sell less. So you have to be aware that if you, as a state, lose a case, it means not only to pay the capital they brought, but the future profits. And who knows what is that? Nobody knows. Now, if the state wins, does he receive compensation from the foreign investor? No, he doesn't receive compensation. So the best scenario for a state is if he wins, he doesn't have to pay. That is the best scenario. So to win is not to lose in reality. But you will have to pay the fees of the lawyers and the arbitrators. According to the UNCTAD, a case is around $8 million. But we were just discussing this case of the Philippines. In lawyers and arbitrators, their budget is around $58 million. So even if the Philippines wins that case, they are going to have spent at least at that moment $58 million.
I think it's quite clear that if there's some countries that benefit from the current arrangements, it's the major Western capital exporting countries who are most of the foreign investment in the world, the foreign ownership of assets. If this system is structured to favor, firstly, investor interests, and secondly, Western interests because of some of the power structures and appointment of arbitrators, then surely it suits the interests of Western countries in general and their companies to have a non-judicial process. One of the defenses governments had was, this is really expensive system, so a lot of investors will never use it. So we don't have to worry to the big players, and as long as we appease them, then we probably won't get sued too badly. But now we have third-party financiers coming in, and it seems looking to gather up groups of small investors who might have some basis for complaint about a state and funding them on speculation that then they'll take a share of any award that they win. The law firms themselves sometimes do that. The lawyers take the case just for free, and if they win, then the lawyers get a big chunk of the money, sometimes as much as 80%, right?
Somehow investors have to have some mechanism to look for redress if they have been mistreated. There are other mechanisms. First of all, you have market-based mechanisms, private insurance. The World Bank has a mechanism that will also insure investors in developing countries against direct expropriation. So if the concerns are legitimate, that they will get their factory expropriated, their goods, expropriated, there are other mechanisms to cover for that. Now, those mechanisms will probably not cover, demands for future profits or indirect expropriation because of loss to in the public interest that a government has implemented. But I'm of the idea that those type of lawsuits shouldn't have a place in the first place. Countries need to sign investment treaties to attract investment, because otherwise, if investors are not protected by investor to state dispute settlement, they will not come. That is a very common argument. Actually, it's a basis under which most of these the basic assumption under most of these treaties were signed, as we were explaining, particularly during the 90s. Now, 20 years later, we fast track, and there's been many studies conducted by academics, but also by international institutions, including the World Bank itself. And at the very least, the conclusions are inconclusive. There hasn't been able to prove a direct link between signing investment treaties and attracting foreign direct investment. And new recent studies by some academics, actually based on surveys, show that investors are not fully even aware of what investment treaty is or what they do, and most importantly, they will not take into account when they make the decision to invest in another country. That is not their main concern. Their main concern is macroeconomic stability, is knowledge of the workforce,
Taxes.
is having exemption on taxes. There are so many other elements that investors will consider first before even thinking about investment treaties. There are also the possibility, if the government really wants particularly company to come, and that company is saying, well, we either get this or we're not investing, there's always the option to do it through a contract. Investment protection treaties are blank checks. You're giving it to everyone without knowing what are they investing, what are they not investing, who are they. So if you're really interested as a country to attract one particular investor, and you want to concede to that investor, that huge privilege of being able to sue the government, you can do it through a contract. And actually that will give you much more leverage to negotiate, and it will even allow you to have a direct strategy, a strategy of, for example, industrial policy, and to differentiate between what sectors of the economy you want to benefit or not, instead of just giving a blank check to everyone.